Welcome to Fasken's 14th consecutive mining series. My name is Virginia Schweitzer, and I'm part of the Fasken Global Mining Group, and I'm also co-managing partner of the Fasken's Ottawa office. Today's hybrid seminar, The Earth is on Fire, What to Say and Not to Say, is the 12th in our series of 14 seminars this year. For our virtual audience, a calendar of all the Fasken PDAC events can be found underneath the video window. Please refer to the slide on your screen for some housekeeping items. Before we begin, I would like to provide a land acknowledgement. At Fasken, we have embarked on a journey of reconciliation, guided by our Reconciliation Action Plan. As part of this journey, we believe it is important to acknowledge the land and the people who have called this land home since time immemorial. Today, in Toronto, where PDAC's conference is being held, we are gathered on the territory that has been the home of many nations, including the Wendat, the Anishinaabe Nation, the Haudenosaunee Confederacy, the Chippewa, and the Mississauga of the Credit First Nations. Toronto is also covered by Treaty 13, signed by the Mississaugas of the Credit and the Chippewa. We appreciate living and working here and recognize the importance of working to advance reconciliation between Indigenous and non-Indigenous people here and across Canada. Now I'll turn it over to my colleague, Emilie Bundock, the moderator of today's session, and who will introduce today's panel. Emilie.
Thank you, Virginia. Hi, everyone. As Virginia mentioned, my name is Emilie Bundock, so I'm a partner in the Montreal office, practicing in environmental law, climate change, ESG, and Indigenous. Thanks for doing the land acknowledgement. It is part of our reconciliation plan here at Fasken. You can find our reconciliation plan on the website if this is something that's of interest to you. I am joined today by, my screen got black. I'm joined today by my Fasken colleagues, Kai Alderson and Sabrina Spencer in Vancouver. So they are our corresponding experts who have saved on greenhouse gas emissions by staying in Vancouver, not traveling to Toronto today. And by my partner, Tony Domenico from our Toronto office. So Kai is a partner in Vancouver, practicing as an energy and natural resources lawyer with a focus on environmental, regulatory, and Indigenous law matters. Particularly relevant for today's session, Kai advises on greenhouse gas reporting requirements and the purchase and sale of carbon offsets, renewable energy certificates, and other environmental commodities. He also regularly consults on the impact of provincial, federal, and regional greenhouse gas reduction initiatives. Sabrina Spencer is based also in Vancouver, practicing in the areas of environmental, climate, and Indigenous law, with a focus on advancing reconciliation and addressing climate change. Prior to joining Fasken, Sabrina was the VP Environment and Regulatory at the BC Council of Forest Industries, where she was responsible for leading the organization's climate change and reconciliation strategies. Thinking of going to the next COP, you should speak to Sabrina. She knows the ins and outs for having been there several times. Last but not least, and in person, Tony is a partner here at Fasken's Toronto office and co-leader of the firm's Competition, Marketing, and Foreign Investment Group. As a former counsel to Canada's Commissioner of Competition at the Department of Justice Canada, and having served as counsel in many of Canada's most significant competition matters, Tony is widely recognized as one of Canada's leading practitioners in competition law and litigation. Greenwashing is no secret for him, and I will strive to give him to share as much of his secrets with you during this session. So the effects of climate change are becoming both more obvious and more destructive. July 2023 was the hottest month ever on record. 2023 has also seen the worst wildfire season in Canadian history, and extreme weather is occurring worldwide with increasing frequency. And 2024 will certainly not be less of an exceptional year. So it will become something that we will have to get used to. As you have probably noticed, it is much warmer here in Toronto at the PDAC convention than it usually is. 2024 has started with warm weather across Canada. I'm from Quebec, and our ski season is just a disaster. So for whoever wants to go skiing, you should pick somewhere else. So if you haven't noticed yet, the earth is on fire. As these events intensify, so too do public expectations for government and corporate action. Shareholders in particular and other stakeholders, civil society, are calling upon governments and companies to do more and faster to preserve the chance of limiting global warming to 1.5 degrees Celsius. The COP28 UN Climate Change Conference in Dubai was the biggest of its kind. Some 85,000 participants, including more than 150 heads of state and government, were among the representatives of national delegations, civil society, businesses, indigenous peoples, youth, philanthropy, and international organizations in attendance at the conference in November, December of 2023. Sabrina will share with us some of the key takeaways of COP28, and note that these include a call on governments to speed up the transition away from fossil fuels to renewables, such as wind, solar, in their next round of climate commitments. International climate pledges are not empty words. They actually translate into hard law and have several and real impact on businesses. Kai and Sabrina will provide a snapshot of the recent evolution of the legal framework related to climate and an update on the carbon markets, both regulated and voluntary or the verified non-regulated carbon markets. As public expectations ratchet upward, businesses struggle to keep up. Although corporate action on climate change was seen even recently as a progressive way to create first mover business advantage, create a distinctive arguments, it is now seen as the bare minimum of good corporate citizenship. The pace at which businesses respond is, however, uneven. That disconnect has caused activists to question whether most, even all, corporate claims on climate are mere greenwashing. These trends create a dilemma for responsible corporate citizens, saying too much and get criticized for greenwashing, or say too little and get criticized for inaction. Some companies are responding by remaining silent. That's often referred to as green hushing. Lawmakers are responding to these criticisms by considering legislation to regulate the use of buzzwords such as sustainable, net zero, green, environmental, in product marketing in particular. Tony will help us demystify greenwashing in an era where trade and competition regulators, such as Canada's Competition Bureau and the UK's Competition and Markets Authority, are dedicating more resources to investigating consumer and public greenwashing complaints. So without further ado, I'll start with you, Sabrina, at a high level with the recent COP28 UN Climate Conference in Dubai. So Sabrina, you're a regular at this type of conference. Could you share with us and with the audience some of the key takeaways of what was certainly the biggest of all COPs?
Sure. Thanks, Emilie. And before I get started, I'll just take a second to acknowledge that I'm very privileged and grateful to live, work, and play on the unceded and traditional territories of the Musqueam, Squamish, and Tsleil-Waututh people here in Vancouver. I think sort of the catchphrase for COP28 for me is that it was really a reality check in terms of the progress that we are or are not making towards our Paris commitments to limit temperature increase to 1.5 degrees Celsius, and also on the fact that compromise is going to be necessary to meet those targets. I think it's fair to say that there wasn't a single country that was happy with the outcomes of COP28. The first big outcome from the COP was this was the first agreement and release of what's called the global stocktake. For lack of a better phrase, it's effectively a report card on how the world is doing towards meeting its Paris commitments. Spoiler alert, we are not straight A students. There is no honor roll in our future at this point. To Emilie's earlier comments, according to the global stocktake, if we maintain the current trajectory we're on, we're actually going to look at a temperature increase of 2.1 to 2.3 degrees Celsius. And for reference, 2023 was the first year when across the board, we did see a 1.5 degrees Celsius increase in temperature compared to historic averages. So 2.1 to 2.3 would have catastrophic impacts for our climate. Out of the global stocktake, there was really two sort of broad avenues where more action is needed. One, I think, is consistent and more aggressive regulation from governments. Of course, we have some countries like Canada where we have instituted a carbon price. Many countries do not. And also consistent regulation on how we're dealing with the transition to clean energy and a net zero economy. The other piece really looks at the fact that this transition is going to be expensive, and the longer it takes us, the more expensive it's going to get. So more commitment to financial mechanisms. From that, I think you're going to see an even bigger interest in what financial institutions, banks, both private and multilateral development banks, are doing to encourage investment in these technologies. And you're also going to see a bigger focus on carbon markets, the voluntary markets, but also the idea of Article 6 under the Framework Convention, which really focuses on the ability to globally trade credits. So if you hear anyone talk about ITMOs, those are the internationally transferred mitigation outcomes. And an ITMO really relies on Article 6 to do that at a large scale. Out of COP28, we did see the first time that fossil fuels have been directly connected to climate change in the language of the text. The final agreed text was transition away from fossil fuels. And this was really sort of the middle ground between a camp that wanted that language to be a phase out and the countries that didn't want fossil fuels to be mentioned at all. We saw an increased conversation around the global goal on adaptation, which has been in the agreement since Paris in 2015, but very, very little work or progress has been made on the adaptation goals. And again, to Emilie's earlier points, climate change is happening and adaptation is becoming necessary. We also saw a real solidification on the acknowledgement that the climate and biodiversity and nature crises are hand in hand and need to be addressed together. So next slide, Emilie, if we talk about what's coming next for 2024, this is another dual COP year. So we will see the biodiversity COP happen in Colombia at the end of October, I believe. And this is going to see new national biodiversity and action plan commitments from participating countries. And these will be in accordance with the Kunming-Montreal Protocol that came out of the 2022 biodiversity COP. So more commitments on restoration and protection of nature. And then COP29, the climate COP, will be in Baku, Azerbaijan. And this will be the precursor to the next round of NDCs, or nationally determined contributions, whereby countries set out their strategies and approaches to meet their 1.5 degree commitments. And coming out of Colombia and commitments that were made in Dubai, nature-related commitments will need to be included in those climate NDCs for the first time. So I think this is the year when we're really going to see the integration of the biodiversity and climate actions.
Thank you, Sabrina. Okay, I'm good. Thank you. So I think you referred to, sorry, this is moving too fast for me. So you referred to on a couple of occasions to the Paris Agreement, which is, as everybody knows, an international agreement on climate change. And pursuant to the Paris Agreement, the parties actually need to set targets to achieve the goals that are embedded in the agreement. And Canada has taken steps to fulfill its commitments, including by submitting its nationally determined contributions under the Paris Agreement. So the current target is to reduce economy-wide greenhouse gas emissions in Canada by 40 to 45% below 2005 levels by 2030. Canada is also committed to reducing its emissions to net zero by 2050. And that's enshrined in the Canadian Net Zero Emissions Accountability Act. So that act, which became law in 2021, establishes the legally binding process to set the 5-year commitments, the targets, as well as to develop a credible and science-based reduction plan to reach those targets. This, of course, is to align with the Paris Agreement, and as part of the Paris Agreement goals, Canada has also submitted its adaptation priorities, because that's also part of what we're going to need to adjust. We're going to need to adapt to climate change above and beyond trying to reducing our greenhouse gas emissions. So Kai, I'll turn to you for some of the regulatory framework on climate that's evolving since those targets have been set by the federal government.
Thanks, Emilie. I really appreciate it, and I really appreciate everyone who's come out today and is participating online. I want to address this topic. It's a big topic. It will necessarily leave many things out, but I want to address it under 3 headings. First, I want to talk about how much regulatory action is happening and is continuing. The goals that Emilie set out are really, they're necessary, but they're very ambitious, very challenging. And I think there's a sense that's settling in maybe that since the Greenhouse Gas Pollution Pricing Act survived the various provincial challenges, it was only 3 years ago. It feels like a very long time ago. But since that time, there's sort of been a settled expectation. We know that the greenhouse gas emissions are priced. There's a federal backstop. There's some variety between provinces and evolution at the provincial level. But it feels like that's just a settled expectation. The question has been asked and answered. And that's a good thing. That's what makes companies respond to these incentives. But I think in line with what Sabrina was saying in terms of the recognition that more action is needed, there's actually quite a lot happening both federally and provincially that will be very significant and needs to be watched carefully by companies in Canada. The clean electricity regulations are coming up soon. There was a significant update released a couple of weeks ago that will in some ways introduce some flexibility, but also represents a hardening in other aspects. The consultation remains open until March 15th, but that I think is one that people should, if they took a look at what was happening in the clean electricity regulation when it was first introduced, you will find it's quite a different regime now. And I think the federal government has been quite responsive to some of the feedback they've received, but there's lots to continue to refine there. Other significant federal initiatives are the oil and gas cap, which has elicited quite a lot of strong responses from some provinces, as can be expected. But again, December regulatory framework introduced, so this is something we're going to be watching over the course of this year, but is really going to have a significant impact, I think. And there are other developments, for example, in the clean fuel regulation and other areas where federal regulation continues to be very active in these targeted areas. And also provincially, So in our province, British Columbia, there have been substantial, significant changes in the regulatory regime. We've moved from a carbon tax to a more federal-style output-based pricing system. We have our own oil and gas cap in the works from a regulatory perspective. And I think across the country, you'll see a number of quite significant provincial regulatory updates going forward. The biggest change over the past couple of years, and this goes on to my second theme, is that we are seeing both provincially and federally a real increase in the kind of carrots and financial incentives that are on offer to nudge companies towards the energy transition, nudge and support, maybe I can call it that, companies as they look for opportunities to support the energy transition, all largely in response to the U.S. Inflation Reduction Act. We've seen the introduction of federal clean energy tax credits. These may be a little slower for the details to be introduced than we would have hoped, and only some of them are we really have draft legislation for. But this is a really significant area, and the devil is in the details. So I know these are working in the sense of seeing projects that are moving forward in anticipation of the energy tax credits coming online, but very important to understand the draft rules as they are evolving, because they really impact structuring and economics very substantially. So that's a huge area. We've seen direct federal and provincial support for new facilities like the Northvolt facility in Quebec. And we're also seeing really interesting, innovative funding. For example, the feds have allocated $7 billion to the Canada Growth Fund to finance what are called carbon contracts for difference. These will be direct sort of funding or financing approaches that will have two goals. On the one hand, they will assist companies through direct financial incentives, and also more broadly, I think there is a not so much a subtext, but a secondary goal of providing some confidence or assurance that carbon pricing will continue. Very significant, and just in December, the Canada Growth Fund announced a $200 million contract for difference structured as a long-term offtake agreement for carbon offsets relating to carbon capture and sequestration. So that's, 200 million there, 200 here, 200 million there. That adds up to real money. And they've expressed an openness to other structures. So not just the long-term carbon offset offtake agreement, but open to other structures. So really widespread focus on direct incentives, carrots, if you will. This is all in response to the U.S. Inflation Reduction Act, which I think the U.S. has tremendously deep fiscal capacity to fund these things. And I think it's going to be an open question. We'll have to keep an eye on whether Canada and Canadian provinces have the same kind of fiscal depth, fiscal capacity, and how much, whether we can compete in the financial incentive game. Final point, and this is where I'll leave you, is sort of a more philosophical point, is around the challenges of climate federalism. When I started these comments, we started with the Greenhouse Gas Pollution Pricing Act, very much a compromise at the federal level, very much working with the grain of the Canadian Constitution, acting as a backstop to provincial action. And that clearly was sufficient to ensure that structure survived the various provincial challenges. And so that it's not like there was perhaps another way of going about it. But what we are left with is a fairly diverse range of policies across the country Canada is not new to sometimes quite acrimonious federal and provincial dynamics when it comes to major policy issues. And we expect to see this continuing to be a major theme in climate policy going forward. Probably at this stage, it's still a little immature, if you can call it that. Like there's a made in X rationale for every policy across the country. Everyone wants a made in BC solution, a made in Manitoba solution, a made in Canada solution. At some point, our provincial markets and our provincial jurisdictions are just going to be too small, and we're going to be deterring some much needed investment in the clean energy transition, whether it's because the polarization associated with federal and provincial dynamics begins to lead to policy outcomes that drive investments away at a provincial level, or whether it's simply because investment needs larger markets if you're looking for carbon markets to support some part of your project. I just think we're looking for an evolution towards larger and larger policy spaces. Doesn't have to all be the same, but more harmonization won't happen as a top-down federal imposition. But I think companies and foreign investors looking to Canada as an attractive jurisdiction are going to be looking for more harmonization going forward. So tracking that, I think, is going to be a very important thing in climate policy for this year and the future.
Thank you, Kai. I think this is a very nice ending to transition to my next question to Sabrina. As Kai mentioned, there's market-based mechanisms in Canada in addition to what's very often referred to as a carbon tax at the federal level. There's a strong case for carbon markets to create incentives to reduce greenhouse gas emissions. In Quebec, we have a carbon market since 2012, and the ton of CO2 equivalent has now exceeded the $50 mark that we were kind of expecting. Like it started around $10, just so everyone understands that, the kind of the increase. Nonetheless, carbon markets, and in particular the so-called voluntary markets, are very often criticized for being maybe less robust or having some lack of transparency or seriousness to them. What are your thoughts, and where do you think we are now, and how this is going to evolve in terms of market-based mechanism for reduction of greenhouse gas emissions?
Sure, thanks, Emilie. So sort of to step back for the carbon markets, to Emilie's point, they did exist before 2015, but after Paris, we really saw an explosion in both compliance and voluntary markets, because part of committing to limit temperature increase to 1.5 degrees Celsius, part of that commitment meant we also globally agreed to a defined carbon pool. So we know how much carbon we can emit to maintain that. So now we're living in this world where we have this carbon balance. So on the compliance market side, you frequently see that implemented as effectively a cap and trade system. So here you can kind of see in the diagram, you have emitter B who is emitting less than their allocated emission amount, so they can sell that difference so that emitter A can offset their excess emissions, thereby creating new income for emitter B to keep improving their processes and reduce emissions. And of course, emitter A also has a pricing mechanism and incentive to reduce their emissions. In Canada, we actually have a number of fairly robust compliance carbon markets. At the federal level, Quebec, Alberta, and BC all have quite, I would say, thriving markets. We've seen an explosion in terms of, the number and type of promised offset protocols. So under a compliance market, you have the parties who can want to purchase those credits. These are the entities that have emissions targets or obligations to meet under a regulation. Through offset protocols, you actually expand the pool of entities that can generate credits. So for instance, at the federal level, we know Canada is working on a BECS offset protocol, so biomass energy and carbon capture and storage. Those entities will start to be able to generate credits in the future. In BC, we have a very hotly anticipated, long-awaited forest carbon offset protocol that, should it ever be released, will allow entities to generate forest carbon credits on Crown land. So we are seeing a bigger opportunity for non-regulated entities in Canada under the compliance markets. The other type of market, and the one that is really important in terms of ensuring that globally we have the funds available to make this transition, is the voluntary market. What drives this market generally is corporate carbon neutrality or net zero commitments. Now, for many reasons that Tony will get into, and as we discovered in the 2024 ESG disclosure study that we completed earlier this year, we are seeing a fairly significant drop in companies making carbon neutral claims. One type of carbon commitment that is increasing steadily, however, are corporate net zero targets. Now, carbon credits can play into this because, of course, if you can't necessarily abate all of your carbon, there is space to purchase carbon credits, but we are seeing increased scrutiny on those net zero commitments, which is flowing through into these integrity issues around the voluntary carbon markets. So to address net zero scrutiny, there's really two paths. There's one, integrity around the carbon markets, but there's also an increasing reliance on net zero framework standards. And I mention this just because the first mining specific net zero standard was actually only released in September 2023. So not surprisingly, when you look at the industry sort of uptake of net zero commitments, mining and metals sectors tend to be a little bit further behind because they haven't had this agreed upon framework. So now that we've started to see these roll out, it is likely that we will start to see more calls for net zero commitments in the mining space. Looking forward to what's next for the carbon markets, integrity is going to be a big issue. If anyone reads The Guardian, The Narwhal, various other publications, there has been a lot of negative press and discussion around forest carbon offset projects in particular. So out of those conversations, we have seen sort of dual integrity initiatives being launched. We have one, which is the VCM Integrity Initiative, as a claims code of practice. And the purpose of this integrity initiative is to allow companies who are making claims based on the use of carbon credits to ensure that those claims have integrity. And we've just seen the first entity, Bain & Company, go forward to have their claims certified under this claims code of practice. We also have the Integrity Council for Voluntary Carbon Markets, and this is the integrity principle that is focusing on the crediting frameworks and trying to create a standard for accountability and credibility on that side. They're still both very much in their infancy. Opinions differ on whether or not they will actually achieve the desired goals in terms of increasing credibility of credits, but I think you are going to see a lot of them happening in the market because there is such a call for improving the transparency, to Emilie's point, and the integrity of crediting products. You're also going to see increased linkages between markets. So when I was talking about COP28, I've mentioned that there hadn't been a lot of progress around this Article 6 and ideas around ITMOs. We are starting to see countries take action outside of the UN framework to start to get some of these international credit market happening. So for instance, I think Switzerland is the country that has made the most commitments, and they have bilateral agreements with 5 or 6 countries whereby Switzerland has agreed to purchase what are effectively ITMOs outside of the UN structure. We're also starting to see some really interesting linkages between voluntary and regulatory markets. So right now, this is primarily happening in countries with less developed regulatory systems than a country like Canada. but you are starting to see some countries look to the more established standards to say, you have a standard, we think it's reputable. Let's work together to try and sort of address some of these issues and also get a carbon market happening in the country. Beyond those fairly major sort of what's next, as you can see on the slide, I think you are going to start to see just a change in language from voluntary to verified. Voluntary has really imparted this, companies are doing it because they want to, not because they have to. And while that is true, the net zero commitments are in many ways voluntary. The public is becoming more critical of them and really starting to expect more from those commitments. So this movement to the verified carbon markets language, I think, is really encompassing that feeling that while these are not regulated and obligatory credit purchases, they are still very high quality credits that are contributing to a goal. We're also, I think, going to start to see an expansion of the types of credits that we're seeing created and purchased. One of the issues that has been a hot topic at COP and elsewhere is this idea of carbon removals. There are a number of sort of schools of thought that advocate for removals not being sort of creditworthy or capable of generating credits. The rationale for that is that if you are removing carbon, then what is the incentive to stop emitting carbon? I think the science that we've seen from the UN, the Intergovernmental Panel on Climate Change, has made it clear that we need to both reduce emissions and remove emissions. So you are going to start seeing more removals credits, I think, being created and purchased. We're also going to see credits move beyond just carbon and emissions. We've already started to see a number of biodiversity crediting frameworks being launched and are in pilot project, including we have some pilots happening across Canada. These biodiversity markets, I first heard about them when I was at COP27 in Sharm el-Sheikh. And then there was, it'll take decades. It took the carbon market really 15 years to get rolling. Well, we're not even 18 months after that, and we already have pilots. So I think the biodiversity nature market is going to come on very hot and heavy for the credit market. And we're also seeing interest in other environmental commodities. So, for instance, water credits, whether those are water quantity or quality credits. Water quality markets do already exist in parts of the world, including the United States. And I think we are going to start to see more sort of commodity trading as we start to really encompass this idea that we can't separate sort of the natural world from our climate change ambitions.
Thank you very much to the two of you. And thanks, Sabrina, for these recent insights on what's coming next to these voluntary or verified carbon markets. Going back to the title of the session, what to say and not to say, I'd like to turn to you two again, Kai and Sabrina, about some of the developments on the disclosure aspect of climate change. We know the Securities and Exchange Commission, after having delayed its climate change disclosure rulemaking, is probably going to announce something tomorrow. So we should have planned this session to be held 2 days from now or tomorrow afternoon. So we don't have the text in hand, but that's a development. Canada's National Instrument 51-107, disclosure of climate-related matters, is also kind of pending. And I think, we'll probably see kind of a more movement once we see what the SEC will disclose. So what are the key developments in climate-related disclosure requirements? And I'll start with you, Kai.
Yeah, thanks. And Emilie, we were so hopeful. We were planning this many months in advance, and we almost made it. We almost had be able to talk about the SEC rules. Final rules will be announced tomorrow at the meeting tomorrow. I'm planning on listening intently, so as others will. So this is more about what to watch for rather than what we know. This was introduced a couple of years ago, almost exactly 2 years ago in March 2022. There were very broad recommendations around including Scope 3 emissions and a very low materiality threshold for climate risk, and it had a lot of pushback, a lot of comments. I think I saw somewhere there were over 14,000 comment letters, much more engagement than SEC rules typically get. And I think that will continue, even though they're releasing their final rules tomorrow. I think there will be litigation and other efforts afterwards to push back, whatever those rules entail. There's been some reporting with anonymous sources suggesting that the Scope 3 coverage will be dropped in order to try to insulate the rules from some vectors of legal challenge. So that's something to watch for. Obviously, just generally the stringency and various details of the rules we'll be looking for closely. The other thing we'll be looking for at and talking about once we learn the rules is how they will deal with foreign private issuers. And so that could pick up Canadian companies. And then how immediate and what the transition path is. Looking to Canada, we've got this situation where Canada both released its draft proposed rules in advance of the SEC draft rules and then hit the pause button. I think the not having the SEC rules released, not knowing where that was going, that was a big issue. Once those rules are released, however they're released, I think that presses the play button in Canada as well. And I don't think, well, we know that the CSA the Canadian Securities Administrators have announced that they're working with the Canadian Sustainability Standards Board. ISSB has released those standards. The Canadian Sustainability Standards Board is looking at how they'll be implemented in Canada. And I don't think once these SEC rules are released, I think the pace and tempo of the CSA will largely be driven by what's happening in Canada. I don't think we're going to wait for the outcome of all of the litigation in the US. And so I think we would be looking for developments later. My guess is later this year, but of course we don't know yet what the timing is. There's been no announcement that I know of in terms of timing from the CSA.
Yeah, and I guess just to kind of follow on that, it's also, Canada has always been a huge supporter of the ISSB. As many of you know, the office for the ISSB is located in Montreal, and part of, I think, having the ISSB in Canada is really reflective of how Canada is going to approach these climate-related financial disclosures. But in addition to climate, sort of my earlier point that the biodiversity piece of this dual crises is catching up quickly, to mirror in many ways the task force on climate-related financial disclosures, we now have the task force on nature-related financial disclosures. And the final recommendations of the TNFD were released in September of 2023. If we compare that to the TCFD, I think it was a 4 or 5 year process to get those recommendations out. TNFD, it was about 18 months. They have been structured in a way that they are very compatible with the TCFD's approach to reporting. And the ISSB has already committed and is already reviewing the new nature-related financial disclosure recommendations for inclusion in future reporting rules. There is already a lot of speculation that particularly in jurisdictions that mandate use of the TCFD, the TNFD will follow closely behind. And again, I think this is something that we will probably see a lot of discussion of in Colombia and Baku later this year.
Thanks to both of you. So now that we know that we'll have to disclose more on climate and on goals related to climate and making more and more environmental claims. I know, Tony, everyone is waiting to hear from you on what they actually can say and what they actually should not say. So we constantly tell clients that, failing to share information about their corporate climate actions is not to their benefit. But at the same time, in May of last year, there was a class action filed in California challenging Delta Airlines' claim to be the world's first carbon neutral airline. And so there's probably something around that feels like, greenwashing that Delta should have been alerted to before making that claim. And so could you please clarify to us, maybe in the first place, what greenwashing actually is?
Well, thanks very much, Emilie, and great to be with you all here today. So I am not an ESG lawyer, so you may be wondering why I'm here, and it's a fair question. The reason I am here is because the agency that I spend a fair bit of time working with has become the hotbed for ESG-related complaints, and the agency happens to have a major focus on consumer protection. So as a result, I've been educated by my learned colleagues and also just experiencing how powerful the movement is to try to address greenwashing or false and misleading representations to the public. Because as you've identified, I think companies are really in a catch-22 today. On one hand, if you don't say enough about your climate commitments, you're criticized by your stakeholders for not doing enough to address ESG-related commitments. At the same time, if you say too much, and if anything you do say can be misinterpreted or misunderstood as false or misleading in any way, you are subject to the crosshairs of various regulators, and I would say the primary regulator right now in Canada being Canada's Competition Bureau. And so that's the dilemma we're in, and companies are in. And so the guidance we're trying to give our clients is how to address that delicate balance and how to avoid getting embroiled in greenwashing. So to your question, what is greenwashing? What it effectively is are false or misleading statements as it relates to environmental claims as a whole. So it's a form of a misrepresentation, notwithstanding what form it may be, that involves green or ESG related claims. I think what I would say is 20 years ago, if you were buying jeans, you probably wouldn't be thinking about the ESG related commitments that jean manufacturer had. You probably had other considerations. And I think the Competition Bureau would agree with you. But I think today the concept of materiality is the representation germane to my purchasing decision to purchase the product or service. I think today the other point is taken for granted, where it's taken for granted and assumed that you are considering the ESG related commitments of a company when you're buying their jeans or deciding where you want to buy insurance or what kind of car you want to rent. All of these considerations now are relevant, and the Competition Bureau actually takes that as verbatim with respect to how to address these points. I'll get into some further comments about the Delta class action in a moment. Before I do that, I want to say that what we're seeing before the Competition Bureau are various environmental groups who are publicly launching complaints to the Competition Bureau alleging that false and misleading representations are being made to the public with respect to various ESG-related claims. And you're seeing a variety of different kinds of complaints, whether it's against the financial institutions or different alliances that may be involved in the oil and gas sector as a whole. I think the Competition Bureau is dealing with these. We haven't heard a lot from them since these complaints have been made, but what we do know is that the complainants have been very public about it. I think they're fundraising on the basis of this and are trying to put as much pressure as they can on the Competition Bureau to move on this. And in turn, when you have this public scrutiny, you also have the requisite private scrutiny in the form of public litigation and private litigation, mostly in the form of class actions. We haven't seen a ton of that yet in Canada, but what we did see in the United States is the Delta case, which is the case where the representation of being the world's first carbon neutral airline being under scrutiny. Because what they're taking issue with in that claim is that Delta is allegedly relying on carbon offsets and sort of participating in the voluntary carbon offset market to substantiate the claim that they are carbon neutral, when in fact they're still emitting, allegedly, greenhouse gases by flying their planes. And so what would the inexperienced, credulous consumer, which I'll expand on later, interpret when they see the representation of the first carbon neutral airline? And I think that's really what's at the core of that case, and taking a hard at the concept of an offset altogether.
I think that's very helpful. Could you walk us through maybe the framework that the Competition Bureau would follow in like receiving that complaint and kind of assessing, you know, whether it's serious and worth pursuing from what you know in that?
Yes. So to take a step back, the Competition Bureau is relying on an old Supreme Court of Canada case called Richard v. Time, which talked about from whose perspective do you look at whether a representation is false or misleading, right? Do you look at the average consumer who may have experience buying your products or services, or do you look at the more inexperienced and the word they use is credulous consumer when doing so? So you're thinking about someone who may not be experienced buying that product or service, right? My parents buying an iPhone, for example. That's the perspective you're thinking about when you're thinking about how would I understand that representation. And at its core, what the Competition Bureau and other agencies do is they say, is this representation false or misleading in a material respect to the public? False is easier to understand. It's either true or it's not true. But misleading can technically be true, but convey a misleading general impression to the credulous consumer. So you've all gone to a mall, you've seen the sign that says 50% off, you walk into the store, and there are 3 items in the back rack that are 50% off and the rest is regular price. The representation is technically true, but arguably that communicated a misleading general impression because you probably thought by looking at the sign that more would be for sale. Conceptually, that's the framework that's being applied here. And in Delta, you know, the average consumer buying a flight and probably thinking about Delta's representations about ESG-related commitments, they probably thought that they may be a carbon neutral airline by emitting less greenhouse gases. And that may be the case, by the way. It's a pending piece of litigation. But what the plaintiffs are alleging in that case is that, no, Delta, you're relying on carbon offsets by your participation in this carbon offset model that may have no relationship with actually what kind of emissions you're emitting. And on that basis, you are saying you're carbon neutral. And that's really what's at issue in that case. And I think that is the kind of case that we can expect to see in Canada. My hunch is that plaintiffs or entrepreneurial plaintiffs are waiting and seeing how the Competition Bureau will deal with the issue. And then once there's sort of a regulatory finding that they may be able to rely upon, then commence the litigation to follow. And again, that's just the competition. As Kai and Sabrina have noted, the SEC is looking into this, and there's a whole securities regime in Canada as well that also may be looking at it from that perspective. But at its core, it's all about disclosure.
Thanks. And what would you say would be the current trends in that area? What are you seeing coming in the greenwashing space?
Well, I think we're seeing a movement. So from sort of what I would characterize as hard greenwashing cases to more softer ones involving net zero commitments. So the Competition Bureau has always sort of been involved in cases where you may make claims about recyclability, compostability when that's not accurate in their mind. So a case you may have heard of is the Keurig case. These coffee pods that were claimed to be 100% recyclable. Well, in fact, they are 100% recyclable. But there are certain landfills in Canada that won't recycle them. And in fact, a lot of them will not. And so you had certain provinces where they were 100% recyclable and others where they were not. And what the Competition Bureau took issue with was, well, you have to, if you're relying upon certain municipalities to recycle your pods, don't make the universal claim across Canada that they're recyclable when in certain provinces that can't be the case. Now, I have a lot of sympathy for Keurig because they have the technology to produce it. It's just that certain municipalities wouldn't do it. But that's the stretch that the Bureau has gone to scrutinize such claims. So I think that will continue. But the trend we're seeing is, okay, how do you deal with the more softer issues where I have a net zero commitment, right? That's going to be contingent on lots of different assumptions being made moving forward. And I think the government of Canada is sort of approaching it in that same way by looking at certain assumptions being made. If those assumptions don't bear fruit, will the scrutiny be intensified? Will there be liability under various regulatory regimes, including under the Competition Act? That's an open question right now.
Thanks. It's very interesting. So if we're looking at, let's say, Canada had those objectives set out under the Paris Agreement, is like came up with a plan to actually meet those targets, has adopted the act which sets the 5-year targets, has to substantiate that with like science-based data, science-based actions that are then scrutinized by, the opposition, the general public. Would that be a framework that, a private entity like a mining company, a mining proponent making those statements of a net zero, what's the level of substantiation of a claim that's required?
Well, I think that at its very basic level, if you're going to be making if a company's making a net zero commitment, there should be a file open with the underpinning that forms the basis of that claim. That seems basic, but it's important to emphasize that. And to the extent that you're relying upon third-party assumptions along the lines of what you're talking about, I think that needs to be memorialized. I think it's a fair position and a defensible position to take, that you are relying upon these other assumptions being met. But that will not be without scrutiny. I think there will be rigor that will be applied to say, why are you making that assumption? And what would be your contingency if that assumption isn't made? And I think someone would look at the overall robustness of the plan to see if it was, from a reasonable person's perspective, viable, having regard to the circumstances at that time. And then having regard to adjustments over time being made, what steps are you taking thereafter? So it's not so much you've made the commitment, you've made your assumptions, and you're not going to revisit it. I think there's an expectation that you will revisit it from time to time, particularly when there are salient updates arising from the assumptions that you made.
So if you say something, you better do it.
Yes.
I think that's a good. I think that's a good summary of what I just heard. So that was interesting in terms of how the Competition Bureau would approach a case. And are there any guidelines that someone should look at or turn to when they're looking into assessing whether or not they should make a claim on their website or other in other cases?
Well, it's a great question. So there were environmental guidelines that the Competition Bureau has since archived. They're available. They're environmental enforcement guidelines that they've been archived because they're a bit outdated. They're so outdated. There was a 2008 draft where they said, we don't want you making claims about sustainability at all because we don't understand this yet, right? Mm-hmm. The train is left. So we know that isn't sustainable. And so as a result of that, the guidelines have been archived, but they're still informative, I would say. But the U.S. Green Guides are often a useful document too. Those are also being updated at the moment, and we're expecting guidance from there. So I think right now, from the consumer protection and antitrust agencies, are a bit behind with respect to updated guidance. So I think you can use their old guidance, but look out for new guidance that should be forthcoming anytime now.
Mm-hmm. Mm-hmm. Thank you very much. So before inviting questions from the audience, I'd like to go back to Kai and Sabrina to share some of takeaways and tips on how a proponent should approach their climate strategy in this era of disclosure and greater scrutiny. So maybe Kai, you can start first.
Sure, thanks. Look, as I indicated earlier, I don't think we know when mandatory disclosure for public companies is coming in Canada, but I think we can be confident that it's coming. And it is actually very technical, can be very challenging, and it's not just an on-off switch. So I think companies that are not thinking about their GHG emissions and disclosure might want to start thinking about how would they disclose on a voluntary basis. And those that are disclosing on a voluntary basis might want a sort of to increasingly maybe review their voluntary disclosures, have third parties, whether they're auditors or consultants or lawyers, review their voluntary disclosures to make sure that they are building up the right muscle memory when it comes to comes to getting ready for mandatory disclosures. So that would be my biggest takeaway.
Yeah, and I guess sort of if I look at it from the perspective of how do you disclose or set yourself up for success when you are making commitments, I think if we look at net zero as an example, we're starting to see a few things that the general public, stakeholders, environmental groups are starting to look for to really have confidence that a company is committed to meeting their commitments. The first one is that interim targets are critical. 2050, while it's getting closer, it's still a long ways away. So where companies aren't making interim targets and reporting against those, we are seeing an increased criticism that it's hard to gauge sort of commitment and progress towards those commitments. If we're talking about net zero, I think I already alluded to it, you cannot completely rely on purchasing carbon credits. So again, you need to show that you are taking action to actually reduce your emissions and then just sort of mitigate the hard to abate emissions by purchasing offset credits. And we are starting to see an increased number of companies, again, referring back to the disclosure study we did, and we spent many, many hours with many companies' disclosures. Companies are really starting to put time into establishing and being public with their policy around when and how they will purchase offset credits. And I think the other thing that we're starting to see is, to Emilie's point, kind of putting your money where your mouth is, starting to show that compensation, and not necessarily just executive compensation, is tied to meeting some of these commitments. So transparency.
Yep. That's a very good point on the compensation aspect, because we're seeing that at the governance level, companies starting to actually implement their ESG related targets into how they give value to the performance, how they evaluate the performance of the leadership team. But I agree, it also tends to go even at the board level and at other levels within the company. That's a very good point. Tony?
What I would say is that there are these new Competition Act amendments that are pending that, if passed, would actually require adequate and proper testing to substantiate any sort of environmental claims. There's a bit of uncertainty as to whether or not it would expand to services, but we know it will apply to products. And so I think it's even more important now than it was before to have a file, some form of adequate and proper testing to substantiate any sort of environmental claims you may be making, and to really put some effort into the substantiation process, whether through your own R&D internally or through third parties trying to certify that. I think it's just become increasingly important, and regulators are going to routinely ask for it if you happen to be investigated.
Thank you. So I'll turn to the audience maybe first, if some people want to start with some questions, and online as well, if you want to post questions in the Q&A box. I don't have any that's showing up right now. Whoever wants to. Otherwise, I'll ask the first question. So I'll ask one question to the three of you. So we as being, lawyers advising in that space, we advise clients basically who are making those claims. Is there a need to advise other stakeholders, and how would that go about? Like, how can we actually educate maybe the general public on those kind of issues and how that can be approached? Whoever wants to take the question.
Sure, I'll go first. I would say that part of that education process quite often falls within the disclosure piece. So I think that's where kind of the increased transparency for me comes from, in that, there is no silver bullet. Nobody is doing this perfectly. And I think where you are kind of on your own corporate carbon, nature positive sustainability journey, bringing your stakeholders along with that is part of the process. It's where you have those gaps that really starts to raise red flags for a lot of stakeholders. And even where there are failures, being public with those and what you've learned from them is going to put you in much better stead than just shoving it under the rug. So I think there is always an education piece, and I think that's part of, for me, where the disclosure has to play as well.
Yeah, maybe I'll go next. Thanks, Emilie, for the question. Look, I try very hard when I'm speaking to stakeholders or other groups or even law students to try to focus in on something that Tony was talking about, where you have a core of what greenwashing means from a legal perspective, the sort of misleading or error, incorrect representations. That's where we're comfortable with. That's where we can advise clients. I think that's where greenwashing really means a lot. But it also has become almost a buzzword that is used to express policy disagreements over maybe the pace of change, and even more broadly, real opposition to market-based solutions or global capitalism. So I try to encourage folks to not necessarily give up on the work, but be clear on what they're saying. I think Tony used the word soft claims, soft greenwashing claims. They may be soft because they don't have a lot of legal content to them, but they're actually the hardest to resolve, the most damaging for companies, and the hardest to respond to because there isn't a standard that's being applied that a company can engage with. There's no adequate and proper testing for being a capitalist. And so it's really important, I think, to encourage people to not conflate the kind of broader critiques and the narrow greenwashing concerns, because all members, all participants in the market have a benefit from a reduction in greenwashing. No one who's investing time, energy, senior level attention wants a competitor to be able to make the same claims with nothing behind it. But I think we do need to keep a more narrow focus on greenwashing properly understood. That would be my comment.
Yeah, I think that we're all collectively struggling, but for the experts in the room, with fully understanding where ESG-related commitments are moving forward. I think, and how much time and effort it will take to meet commitments and what those commitments ought to be. And I think government and private enterprise are working through this or thinking it through as they move along. So I am confident that it will become clearer over time once a lot of these regulatory issues, I would say, about disclosure get cleared up.
Thank you. And I'll ask a question that I was asked before the, okay, I'll take your question and then I'll ask the question I was asked by someone before the panel.
My question is with regards to the role that banks can play in terms of furthering the transparency of information and disclosures. One thought I had, I work for Canadian Bank on the lending side, and I'm curious as to whether you see any disclosure reporting requirements, and if perhaps that's a way to kind of advocate that businesses should be thinking through the disclosures, even though it's not currently legislated. So just wondering both on, that specific covenant reporting requirement outside of the sustainable finance products, where certainly we do see that. I have not seen it in the Canadian marketplace, but I think it's one way to further the dialogue. But just generally speaking, what would you like to see Canadian banks doing to help?
Who wants to go first?
Well, maybe I can speak, and we do advise some major financial institutions on this. I'd say that banks are already recognizing their central role as lenders and providers of capital, and they're already doing quite a bit. I'm not sure that more regulation beyond what's already in place from OSFI and others is going to really be what's required. I think all of the banks are aware of the concerns that have been raised. There are complaints recently, for example, from the Investors for Paris Compliance on the 5 major banks around the use of the term sustainable finance and what that's doing. And I think banks really are taking a lot of steps internally and through their disclosure to represent what they're doing accurately, and that obviously should continue. And I think this is not a risk that's sort of unseen in any way, I would say. But it is challenging. Large institutions, a lot of folks involved, and can be very challenging to line up the policies, the disclosures, and the frontline decision making from lending officers and others.
Yeah, and I guess just sort of by way of background, before I transitioned into law, I was head of sustainability at the Canadian arm of an international bank. And I can say that these conversations have been happening for longer than I care to admit to being aware of them. I think, we are already starting to see increased scrutiny on financial institutions. And I think part of the expansion of disclosure and reporting on financed emissions is going to see increased sort of risk mitigation value to looking deeper into customers' disclosure on climate and nature-related issues. And to Kai's point, we're already seeing that happen to a certain extent in certain sectors, in Canadian banking sectors. You are starting to see some banks trying to push the envelope a bit. I think it was Rabobank maybe in the Netherlands, but they have recently started using an ESG-focused risk rating system for real estate lending. So I think you are going to start to see banks pushing the envelope a little bit. And I guess one positive for the sector when there's that much global focus on what you're doing is a lot of banks, as they're trying new things, are being very public about it. So hopefully the learning curve is a bit sort of more communal as we move forward and find new ways to consider these issues.
All I would add is that we now see in Canada complaints against financial institutions, both in the competition and the securities context. So I think the scrutiny is out there. I think banks are clearly a target, not only because of the institutions themselves, but who they lend money to, and trying to control or impact the bank's behavior as it relates to who they provide their lending to and what kind of conditions should apply to that. So I think that's really at the core of it. And what the bank's responsibilities for that's still an open question. But I think clear and transparent dialogue about what they are trying to do and what they're actually doing and making that distinction, I think is an important point as well.
Thank you for the question. I have 2 questions here coming from the online audience. So the first one is, are most of the existing Competition Bureau claims related to carbon offset? And has the Bureau made any decisions about these types of claims yet?
I would say most of them are not about carbon offsets. What they're about is they range from, you say you want to achieve net zero by 2050. We don't see the plan for that kind of approach, or kind of scrutinizing the underpinning behind the claim, to things like using the word clean energy or natural gas, or sort of these phrases that suggest cleanliness or environmental friendliness when it's in fact not the case as argued in the complaint. So it's a wide-ranging series of complaints involving those kinds of things. Again, I think the Bureau's had them for a number of months now, and we're waiting to see how the Bureau is approaching it. Like, I don't know what in fact is going on internally, but I was with the Competition Bureau, and so this isn't insider knowledge, but just my assessment is that I think they're thinking hard about how to address these things on the collective, as opposed to looking at each individual complaint. Although they are distinct, there are some commonality in theme between many of them, and I think they're thinking long and hard about that before they follow up.
Thank you. The next question from the audience online is, do you see a widening gap between public and private company behavior due to increased regulatory compliance? And might this be problematic? How might customer or market behavior react? So that's, the kind of the difference between public and private companies on those issues. Maybe
Okay,
Kai or Sabrina.
I think there's actually a lot of things happening that are narrowing the gap between public and private companies. So, for instance, California recently introduced a new bill that if you are a company, public or private, operating in that state that has a certain threshold of operations, I think it's maybe 50 million. It's large, but it isn't huge. You are required to issue climate disclosures. So I think we're going to start seeing more regulation like that. You're also starting to see some large companies, Aviva is sort of the one that is held up as being the leader on this. They are requiring their suppliers in certain sectors to provide and meet certain climate related goals. So I think you are starting to see the larger, regulators start to see that there is a potential for a gap, so trying to address it. And then you're also seeing some of the larger public companies who have obligations really start to hone in on their scope 3 or the emissions that are influenced but not directly within their control, really start to hone in on those and push sort of the obligations and commitments down their value chain.
Yeah, so that's an interesting one. The scope 3 emissions tends to expand at the outreach to the private entities just by virtue of them being a supplier, a customer, or other stakeholder involved somewhere in the supply chain of a publicly traded entity there. That's certainly something. So I'll ask you the Super Tuesday question that I was asked just outside in the hallway before this session. Do you foresee anything happening to these developments around climate-related disclosures in the US in particular, and then certainly coming to Canada as a result of the potential changes in government? Who wants to take the question first?
Well, okay. I think,
And we could say changes in Canada as well. I think it's not only, it's a Super Tuesday question, but it could be also a Canada question.
I think I'll begin because people are using my area of law as sort of the framework for this. So in many U.S. states, there's a real concern about companies collaborating with each other for the purposes of their environmental commitments they may collectively wish to make. Now, technically, there is a criminal prohibition under competition laws that prohibit competitors from entering into agreements to fix prices, allocate markets or customers, or restrict output or supply of products or services. So technically speaking, if you're seeking to agree on a limit on greenhouse gas emissions, there's some interpretation that that is a restricted output, and that might amount to a criminal offense under the Competition Act. So many companies have said, hold on, we're not doing this anymore because I'm worried about antitrust scrutiny. And I think many states have sort of taken the position or used competition law as a bit of a sword to discourage that, among other political rhetoric you're hearing about sort of ESG-related commitments as a whole. But that is we're seeing a lot of on the state level. I don't anticipate that happening in Canada. For one thing, the competition laws are federal in nature, and so there's really only one government who's dealing with it, and provinces don't tend to get engaged in that kind of thing. And I just don't see a change in government in Canada impacting that very much, or trying to see capital P political politicians trying to get involved in otherwise law enforcement agency that is at arm's length away from the public, from the federal government. So I don't really see that kind of dynamic working here. And what I instead see is a bit more of this robustness as it pertains to greenwashing continuing, even in the context of a change in government.
That's interesting. Any insight from Vancouver?
I mean, this is almost. I always hesitate for lawyers to become pundits, but I'm willing to take it up for a moment. I mean, I cannot imagine if a Trump administration in which there would be a lot of pro ESG activity, or there would be, obviously there would be a lot of effort to stripping away some of the things that we're seeing. On the other hand, I mentioned we're sort of moving towards more carrots in Canada. The Inflation Reduction Act in the US is like all carrots all the time. And that's passed by law. And again, we'll have to see what the election results would be, but hard to see that getting stripped away entirely. So I directionally, I don't think we're really any longer at a risk of a huge reversal, maybe some delays, maybe some timing changes. And I agree with Tony that the Canadian political dimension, even though these issues are front and center, as they should be, these are important public policy issues with very large funding demands and impacts on the Canadian economy and society. So right that they should be center stage. But I don't see quite the same level of polarization where technical solutions that are broadly accepted in Canada would be reversed summarily. So I think I don't see that as a huge change north of the border.
Yeah, and I would just add that I think there's considerations sort of outside of domestic politics that are really relevant to this now. So for instance, the EU, as is generally the case, is leading the way on a lot of regulatory pieces, and the implementation of a carbon border adjustment mechanism. So if you don't have a carbon reduction or a carbon tax regime in your home country, you effectively have to pay a carbon-based duty to import goods into that trading market. I mean, things like that are really going to impact, I think, domestic policies for export-based countries like Canada in particular.
Thank you. I think we're almost at our time. So we're coming to an end. Is there a last question maybe in the audience? Otherwise, I'll thank you all for joining us today. And as you are interested in these issues, if you haven't done so yet, I strongly recommend you download the Fasken ESG Disclosure Study, which is essentially a benchmark survey of ESG-related disclosure and practices by Canadian public companies. The study covers topics such as governance of ESG issues, ESG disclosure, ENS, so environmental, social goals and targets, shareholders' proposals, social issues, forced and child labor, Indigenous engagement, and forward-looking information. And I think I just lost the note about our next panel. Oh, here it is. So our next PDAC session will be taking place here again in a few hours at 3:30 p.m. Eastern Time, and will be on the topic of South Africa's exploration potential as a sunrise industry. We hope you join us at that panel. Thank you very much and have a great day. Enjoy PDAC conference, of course, and thanks to you all online.